Well, hello and welcome to Tom's Next Level Exam Prep video for Agency. I'm Tom, and I've helped hundreds of students pass their exams and start their real estate careers. My Next Level Exam Prep video series is designed to help you do the same thing. I really urge you to watch my Welcome and my Exam Insights and Strategies videos for a complete overview of this series. You will learn how to get the most benefit out of these topical videos. So here's a quick recap from my welcome video of some important points. In my exam prep video series here, I'm putting you in test world. We're not talking about real world information. I'm just focusing on the exam and those things that you'll see on the exam. And of course, these videos are designed only to supplement your educational course provider's materials. I'm not going to reteach the information, but we're going to dig deep into the information you already have and show you how it's going to come out on the test, okay? And I urge you for that reason to take lots of notes. There's a lot of information in the videos here that you won't see on the slides. So the more notes you take, the more you're going to remember, the more likely you are to do very well on the test. So again, encourage you to make a lot of notes. So with that being said, it's time to grab your course materials, your notebook, and your positive attitude, and let's get started with agency. Very important to understand that agency equals representation. I want you to think about that every time that you see the word agency in your coursework or in a test question. When you see the word agency, if sometimes it gets confused about what they mean, think about representation. What's an agency agreement? Well, it's a representation agreement. Here's an idea. What if I asked you, what is a seller agency agreement? What's a common name for a seller agency agreement? Well, that would be a listing. It's just a different term for a listing, okay? So if you think about seller agency agreement, substitute the word representation anytime you see agency, and you come up with a seller representation agreement. Oh, that must be a listing. So that will help you get through some of those confusing sentences they put together in the test about what exactly do they mean. Now, with an agency relationship, now remember, with regard to agency at this point in your course materials, we're talking about the common law of agency across the country. So national topics, common law of agency, not just real estate. There's a lot of different types of agents out there, okay? There's talent agents, sports agents, insurance agents. So what is an agent? An agent is anybody who is employed by somebody to represent them. So in an agency relationship, there are two parties. There's a principal and an agent. Okay? The principal is the one who does the employing. They employ somebody to represent them, and the agent is the one who is employed, okay? Doesn't matter, again, if it's a sports agent, talent agent, whatever it might be. So two parties in an agency relationship, principal and agent. Now here's some vocabulary for you with respect to agency that you have to keep straight, okay? The difference between a client and a customer, sometimes referred to as a third party, actually sometimes referred to as a consumer. A client is anybody who has signed an agency agreement, or what did we just say? An agency representation agreement, like maybe a buyer or a seller, a landlord or a tenant. When you have a seller who signs a listing agreement, that means they've signed their agency agreement and they're hiring the broker to represent them. A consumer or a customer or a third party is not somebody who has an agency agreement signed. They're not represented. They have not signed any kind of a representation agreement. Can you still work with consumers, customers, or third parties? All synonymous. Can you still work with them? Sure. Depending on your state law, you run some risk. You may or may not get paid because there's no agreement to get paid with them. But can you work with them? Yes, you can. So that's my note at the bottom of the slide. I want you to watch out for that on the test. Here's how it's going to show up on the test. You'll see the question phrased 2 or 3 different ways. Tom is working with a buyer, and the buyer has some questions about what they should do next. What should Tom do at that point? Well, the question said Tom is working with a buyer. That's the trigger in the test for letting you know that that buyer is a consumer. Tom doesn't represent them. So when a consumer or a customer asks you as an agent, what should they do about something, you have to caution them, I don't represent you. If you'd like to sign a buyer-broker agreement, I'd be happy to represent you and I can give you some advice. But be careful if you don't represent them about giving advice. So watch for the term working with in a test question. That'll be the trigger to let you know that that buyer, in this case, is a consumer or a customer and is not represented. How else would the question be phrased? Oh, Tom represents a buyer and that buyer has some questions about how to proceed or what to do next. Well, that's a pretty clear-cut case because it said Tom represents a buyer. So watch for those two comparisons on the test. Represents versus working with. Working with is a trigger to make you know that it is a customer. Let's talk about the types of agencies that we're going to see on the national test. 4 different types of agency, and misnomer, 3 different types of agency, and 1 type, facilitation, which isn't really agency because it's not representation. But let's go through these. There's buyer agency and seller agency. Pretty clear cut, pretty direct. There's also dual agency. Now you should know not all states allow dual agency. In a single agency state, you can either represent buyers or the brokerage can represent sellers, but the brokerage can't represent both buyers and sellers unless that state allows dual agency. So many states are single agency states. Some brokers will be set up only to work with buyers. There'll be another brokerage set up that only works with sellers. Now, some states do allow dual agency. Quite frankly, I'm up here in Minnesota. We, as a state, allow dual agency. There are some states that think we're absolutely crazy to allow dual agency, because how can you represent both parties to one transaction? Because think about that scenario. If a seller lists their house with a broker and a buyer lists their house, or a buyer signs an agreement with that same broker, and that buyer wants to buy that seller's house, then the broker is representing both parties. And that's dual agency. So here's some things I want you to make a note of. Is dual agency a conflict of interest? Yes, absolutely. That might show up on the test. It is a legalized conflict of interest in those states that allow dual agency. What's the other impact of dual agency? Dual agency allows only for limited representation to either party. You can't give your full representation. You can't disclose things you know about one side versus the other. So dual agency clearly is a conflict of interest, and it allows only for some limited representation to the 2 parties involved. Now, the 4th type of agency here, which again is really non-agency, is facilitation. That's what you might do with a consumer or a customer. You can help them without representing them. Some states allow that, some states don't. I think a lot of states allow it. However, you may have some issues getting paid if you don't have any kind of a representation agreement and a commission agreement with somebody that you're a facilitator for. But let's assume this happened. You're in an open house and a consumer walks in the front door at your listing, your open house, and says, we'd like you to help us find a house. And you're going to say, well, okay, would you like to sign a buyer-broker agreement? Would you like me to represent you while I help you find a house? For whatever reason, they might say, no, we just met you. We're not sure we really like you that much, but we'd like to have you help us find a house. So now, can you still help them go find a house even if they don't sign a buyer-broker agreement? In many cases, you can check with your state, but you don't have a representation agreement for sure, so there's no assurance that you're going to get paid if you do find them a house. But in that case, you'd be working with that consumer, and you can help them, show them houses, you can take them out, and at some point in time, they're going to say, again, what should we do, or what would be your counsel on what our next step would be? And you have to say, time out. I don't represent you. I can help you do what you want to do, but I can't advise you on what you should do because I don't represent you. So those are the pitfalls with being a facilitator. Some states call it a transaction broker. Some states say they don't represent the party, they represent the transaction, okay? It's actually a non-agency relationship. Now, bear this in mind for the exam. Some states might require a signed facilitation agreement explaining the duties or non-duties of both parties. Minnesota, in my case, does not require a signed facilitation agreement to work with or help a potential client. So those are some things you want to drill down into your state material and whatever they're addressing in your state for your national material. But there's 3 types of agency and 1 type of non-agency. Okay? Buyer, seller, and dual, and then facilitation. Well, this is where I want to spend a little time with you in this video, talking about agency relationships within your brokerage. Okay, so let's talk about the 2 things we started with up front. There are 2 parties, let me get my 2 over here. Where's the 2? There we go. 2 parties to an agency relationship. One that employs the agent. The principal employs the agent to represent them, and the agent is employed to represent the client. And this is where our word salad gets tied up for people on the test very often, because we're talking about agents and brokers and principals and clients. So let's walk through this real simply. When a seller or a buyer employs a broker to help them either sell a house or find a house to buy, the client is the principal in that agency relationship. The broker is employed by, let's say, a seller to help sell their house. So because the broker is employed by that seller in an agency relationship, that broker, is the agent for the seller. So in this case, the broker is the agent. And you go, whoa, wait a minute, how am I going to keep all this straight? Think about the agency relationship players. Principal, agent. Principal and agent. There's only 2. So the client has hired the broker and employed the broker to represent them to accomplish the client's goals. So the client's the principal and the agent is the broker. All right, here's where our word salad gets really interesting. Okay? What's your relationship as a salesperson to your broker? Your broker has hired you or employed you to represent them as the broker. So the broker has employed you to represent them. So they're the principal in that agency relationship. You've been employed by your broker to represent them. So you are the agent in that agency relationship. So you can see on the slide, the broker is your principal and you are the agent of the broker. Now some key points, I want you to write these down. The broker employs you to represent them as the broker. Does the broker employ you to represent the clients? No. The broker has hired you to represent them. The client has hired the broker to represent them as the client, but the broker has hired you to help them represent the broker and to help the broker represent the client. Right? Got it all? No, I know. That's why we do these. That's why I do these videos. The broker and the salesperson, that agency relationship. The broker is your principal. Here's a good way to remember this. Make this note. Be smart. Your broker is your one and only principal in real estate. They're the only one who has employed you directly to represent them. So you have no other principals in real estate other than your broker. Very likely going to be a test question. In a real estate brokerage, you're a salesperson. Who's your principal? They'll have choices. Is the broker your principal? Is the client your principal? Is an investment partner your principal? They'll have some dopey choices. No, your only principal in real estate as a salesperson is your broker. That's another test question you should get right. And you are an agent of your broker because the broker has employed you. Now that leads to an interesting scenario. Now, as we put all this together, look what we have here for a hierarchy in a brokerage. Starting from the top, the client has hired the broker to represent them. So the client in that agency relationship is the principal and the broker is the agent of the client. But now let's stay in the middle with the broker. The broker has hired you to help them represent the client and the firm. So the broker is the principal who has employed you in that agency relationship. You're the agent. So we're throwing the word agency around here and agent and all of that. Here's why students get confused, and understandably so. In agency relationships, the broker is both an agent and a principal. And students say, well, I thought I was the agent. Well, you're an agent of your broker, but the broker is also an agent of their client. So just be aware of that. The broker is both an agent and a principal in the brokerage. They wear both those hats. And remember this, just as an aside, make a note of this. I know you get it in other parts of your curriculum there. The broker owns all contracts. When a listing or a buyer-broker agreement comes in from a seller or a buyer, who owns that contract? The broker owns the contract. And here's another confusing element in the early stages of your real estate career here. You as a salesperson went out and found a friend or a relative or somebody, one of your prospects you found through social media. And they want your brokerage and you to help them sell their house. So you went to somebody's house and they signed a listing agreement with the broker. And you sign it and you bring it back to the brokerage. Well, whose listing is that? That's the broker's listing. No question about it. That might show up later on in your career. You realize that if you ever get upset with a broker and you say, you know what, I don't like this brokerage anymore. I don't want to work with you anymore. I'm going to put my license with a different broker. So I'm leaving this brokerage and I'm taking my listings with me. Well, good luck with that. The broker's going to say, sorry to see you go, but they're not your listings. I don't care how hard you worked. That client didn't hire you to help them sell their house. They hired the broker to help them sell their house. And then your broker hired you. Since you went out and got that listing, you secured the listing, your broker says, good job. You are the listing agent. You get to work on that listing because you went and secured the agreement. But the broker owns the contract. Okay, never forget that. And also, in the agency relationships in a brokerage, the broker, once again, is both an agent and a principal. Well, let's talk about the different types of agency you'll see on the test. 3 main types, and you need to know the significant difference here between these 3. Special agency is an agency relationship where the agent has no ability to bind their principal to do anything. Second type is general agency. It's another type of agency, but under general agency, the agent has a limited ability to bind their broker. Let's talk about my previous example. You went out and secured a listing. You sat with the seller signed the listing agreement, and you as the salesperson signed the listing agreement. And you brought it back to your brokerage, and the broker accepted it. Well, who owns that contract? The broker. Well, since the broker owns that contract, doesn't the broker now accept certain responsibilities that are in that listing agreement to perform and acts to perform for that seller? Yeah, so you have bound your broker to do certain things by signing that agreement. And that's good because your broker gave you that authority. In your employment agreement with your broker, they said you go out and find listings and you sign them as a salesperson. And when the broker accepts everything that was signed, then the broker is ultimately responsible. But you bound your broker to that listing when you signed it. We'll talk more about that in a minute. The third type of agency, you just have to know some key facts for the test, is universal agency. That's where an agent, now we're talking principal-agent relationship here now, not real estate agent. An agent of a principal is given an unlimited ability to bind their principal. Carte blanche, whatever they sign, the principal says, you go sign for me, that's fine. And then the principal is obligated to perform. Well, how has that ever happened? Well, I've not had this happen in my career, but I know a couple situations where some friends of mine, agents, did have this happen. It's kind of interesting when it does. Picture this scenario: a high-profile entertainer, sports figure, whatever it might be, somebody that the public would be well aware of and know their name of. They're going to move to an area and they want to buy a house. But if somebody knows, let's say it's a high-profile sports figure or entertainer, they want to move into a neighborhood. As soon as the seller finds out who the buyer is, price might change, right? So there's a good chance of that. Might take away some of the buyer's negotiation ability. So those types of people, sports agent, entertainer, might say to a real estate salesperson they know, I'm going to give you unlimited ability to bind me to a contract, because here's what I want you to do as my real estate agent. I want you to look for homes, keep me informed, send me pictures, but do not tell the seller who I am. And I want you to sign all the documents, and I want you to get it right up to the point of closing. But the seller has no idea who the client is, because that seller, that principal, has given their agent universal agency to sign for them and to represent them without divulging their name. So that's what universal agency is. Here's a couple points for the test that you'll want to know. Two things. First of all, power of attorney. Power of attorney is a document. Some people say, oh yeah, I was given power of attorney. No, you weren't given power of attorney. What you did was you signed a power of attorney document. When the document is signed, it created something called an attorney in fact. So somebody with unlimited ability to bind their principal with universal agency is an attorney in fact, but they are an attorney in fact by virtue of signing a power of attorney document. So if you can keep those two things straight, just a little more minutia to remember for the test. Well, this shows you how those different types of agencies show up in a real estate brokerage. Remember, we said a special agent is one who has no ability to bind their principal. Well, that's going to be the relationship between the broker and the client. The client has signed, let's use a listing agreement as an example. The client has signed a listing agreement. So the broker doesn't have any ability to bind their seller to anything. So what the broker can't do is call the client up after a holiday weekend and say, you know what, we had a good offer on your house while you were out of town. So the broker tells the client, I knew you'd like it, so I just signed a purchase agreement for you, and your house is now sold. The broker can't do that. They can't do that because there's a special agency relationship between the client and the broker has no ability to bind that client to anything. All the broker can do is inform the client and let the client make decisions about what they want to do. Now that's different than the relationship between you as a salesperson and your broker. Does your broker give you permission to sign documents for them, all like listing agreements and buyer-broker agreements? Your broker has told you if you sign those and bring them back to the brokerage, then the broker will accept them and be responsible for them. So you have a limited ability to bind your principal. And remember, your one and only principal is always the broker. So that's a general agency relationship. If that helps you understand the distinction there, I hope so. Watch out for that on the test. Special agency, general agency. And on the last slide, it said the universal agency was an unlimited ability to bind a principal. In an agency relationship between a principal and an agent, the agent owes fiduciary duties to their principal. So, pause for a second. Who's your principal as a salesperson? Your broker. You owe these same fiduciary duties to your principal, to your broker. Who's the principal for the broker? Well, that's the client. That's going to be the buyer or the seller or the landlord or the tenant, whoever signs the agency agreement. So the broker owes fiduciary duties to their clients, who are their principals. And now take a look at the bottom of the slide. I want to jump down there real quick. Salespeople owe the same fiduciary duties to the firm's clients that you owe as a salesperson to your broker. And that's a key bridge right there to be aware of for the test. But let's talk about what those fiduciary duties are. And I've got some tips here on how they're going to show up for the test. There's an acronym to remember. You can use old CAR as an acronym to remember these 6. There's some other acronyms out there, but the first one is obedience. You have to obey the lawful instructions of your client. Now, I'm going to ask you to make some notes along here. I'm going to encourage you to do that because there's some tips here for the test that aren't on the slide, but I'm going to give them to you as we go through. The key word with obedience is lawful instructions. So you will see a test question that says something like, your seller has asked you not to disclose the fact that they had a wet basement because it was only wet for a while and they fixed it up and they patched it up. So they're telling you they don't want you to disclose that to any potential buyers. Can you do that? No, you can't. That is not a lawful instruction. The question might be, what do you do in that case when your seller says, I don't want you to disclose that material fact? You have two choices. Convince the seller that they need to disclose it because you have to disclose it as a salesperson, or walk away from the listing. Run away from the listing. You can't take it. Cancel a listing if you've already signed it. You cannot follow unlawful instructions. There'll be a question worded somewhere along those lines on the test. Loyalty. Loyalty is another one they'll have 2 or 3 questions on. Loyalty fiduciary duty says you need to put your client's interests above all other interests, including yours. And the example they often use is an agent, Tom. Tom is an agent and he has 3 listings to show a buyer. 2 of the listings pay a normal commission. 1 of the listings pay a greatly reduced, very small commission. So Tom is wondering what to do. Should he show the house, all 3 houses to his buyer? Or Tom might decide to only show the 2 houses that pay the best commissions and not even show the house that pays the lower commission to his buyer. If they do that setup on the test question, here's going to be the ultimate question at the bottom of the paragraph. What fiduciary duty did Tom violate? And the answer is going to be the fiduciary duty of loyalty, because I put my interests above the client's interests. So I'm trying to make the point that's how they're going to ask some of these questions. The questions might be, what does the fiduciary duty of loyalty involve? Or the question might be, here's a setup in the exam, in a paragraph in the question, and they'll say, here's what Tom did. What fiduciary duty did Tom violate? So you might see it both ways. Disclosure. You have a lot of things you must disclose as a real estate salesperson. As a licensee, you have to disclose, number 1, all material facts. You know that from your other coursework. You have to disclose what you know about a property. You can't follow the seller's illegal instruction and say, oh, no, I don't know that. You have to disclose whatever you know. There's other things as a real estate agent you have to disclose. Whether or not you want to buy the property, if you're the buyer. We'll talk about some of those things in just a minute. But in this disclosure, we're talking more about material facts. You have to disclose everything you know about that property to your seller and to potential buyers. Okay? You have the fiduciary duty of confidentiality. That means anything you learn because of the agency relationship with that client, if it's a listing, anything you know about the house while you list the property that you didn't know about it before, you have to keep all of those things confidential. Anything you learn about your seller's financial situation, whatever it might be, anything you learn because of that principal-agent relationship, you must keep confidential. And I made a little note there because on the test it's going to ask you, how long do you have to keep that information confidential? The short answer is forever. As long, even after the listing expires or the transaction closes, you must keep things you learned because of that agency relationship confidential forever. Do you think that gets violated on occasion in the real world? Yes, but we're stuck in test world here, so that's the correct answer. Okay? Accounting. Accounting is not debits and credits and balance sheets in this case. Accounting is accounting for anything that you might have gained from the seller or learned from the seller or the seller may have given you to help show the property. We're talking keys, garage door openers, things like that. Maybe a card to swipe to get in a security door. You have to account for all those things once you're done with your agency relationship. And the last one is reasonable skill and care, which is really pretty subjective, right? And it's meant to be that way. That's sort of a catch-all basket to anything we might have missed in the first 5. Just be reasonable. So that if there's a problem down the road, a seller might say, Tom didn't exercise reasonable care. So just be aware that's very subjective and that's by design. And I'll reinforce and restate again that you as a salesperson owe the same fiduciary duties to your broker and to the broker's client. Even though the broker owns the contract, you still owe fiduciary duties to that broker's client. I mentioned a minute ago that there are other disclosures you have to make as an agent. Real estate salesperson being an agent of your broker. You certainly have to disclose your agency relationship to anybody you meet who you might be doing some real estate business with. You have to disclose who you represent and who is your principal. When do you have to do that? You know this phrase from your coursework, the first substantive contact. Well, what's the first substantive contact? That's really going to be any discussion of price, terms, or motivation. So the scenario is you're in an open house. It's one of your listings. You brought it in, the broker accepted it, you get to sit in the open house, a consumer walks in the front door. I said consumer, right? You have never met him before. Right now, as far as you know, they're a consumer. You don't know if they're under contract to another agent or brokerage or not. So they walk in the front door and they start the conversation this way. Hello, nice to meet you. My family's here and I want to tell you that we're looking very much forward to moving to this area. And actually we're in kind of a bind. We need to move very quickly because my employer just transferred me here, but we want to spend in that $300,000 and $350,000 range. We need 4 bedrooms. We need to move fast because my employer just transferred us here and I'm ready to pay cash for the house. What do you do? That might even be that's a long setup. There might be a shorter version of that in a test question. So now what have they disclosed to you right off the bat? Price, terms, motivation, right? Here's what I'll pay. Here's why I got to move. And here's my terms I'll go with. So what you need to do with them immediately is to say, time out. Just stop for a minute and relax. I have to disclose the fact that I represent the seller. And you have to have that discussion about agency. You have to tell them what their options are. Sometimes it's in writing. Some states use a written form. Some states just say it just has to be done orally. Check with your state. In Minnesota, we have a written document. It's a disclosure of agency document, and it lists the 4 things we talked about earlier: buyer agent, seller's agent, dual agent, and facilitation. But the key point here is that you, as a salesperson in that setting and in that scenario, have to tell that consumer who's standing in front of you, don't tell me anything you don't want me to tell the seller, because I now disclose to you the seller is my client. I represent the seller. And you have to explain to them, no matter what you tell me, not only can I tell the seller, I have to tell the seller, because the seller is my client. So you need to stop people before they go too far with all that and say, take a look at this agency relationships disclosure, whatever your state calls it. And what the form does is to disclose to that consumer who just walked in your open house what their options are. We need to carry that message to those consumers when they walk in the front door. You have an option to be, as a buyer, you have an option to be represented or not be represented. If you sign a buyer-broker agreement with me and I represent you, then whatever you tell me, I can keep confidential. But if you don't sign that buyer agency agreement, then whatever you tell me, I don't have to keep confidential, and I have to tell my seller, because they're the one I have an agency agreement with. So all of that varies by state, but I want you to be aware that you have to disclose your agency, in this case the fact you represent the seller, at the first substantive contact. Okay? You also have to disclose to people that you're working with if you have any conflict of interest. For instance, selling or buying your own house. Can you put your own house in the MLS and sell it? Sure. There's no problem with that. Typically, you put it in the MLS, and what you do have to disclose, though, is that you're the seller. Once you get in the MLS, you'll see this. It's very often, very, very common. House for sale, one tagline says, by owner agent. That's the disclosure that I'm the listing agent, but I'm also the owner of the house. Can you go out and buy a house for yourself? Can you look for houses in the MLS and find one you think you like and go buy it? Sure, there's nothing wrong with that. But what do you have to disclose to the seller? Well, the buyer's me. I'm the buyer. I'm representing myself. You can't play some negotiation game and say, oh, I have a very interested buyer, but they really need the lowest price possible, and you're the buyer. You can't do that. That is defrauding and misrepresentation. So if you're a buyer or a seller, you have to disclose that, okay? What if you have a financial interest? What if you want to get involved in buying homes, fixing them up and selling them, and you've got 2 or 3 of your pals you're working with, and the 3 or 4 of you get together and form a little limited partnership. And now you're the one that's the point person because you have the real estate license. You're going to go out and look for homes that are for sale. So you're looking for homes for sale for your limited partnership that you're a part of. Do you have to tell that seller that you have a financial interest in this, that you have a financial interest in that limited partnership? Of course you do. You have to disclose that type of financial interest. And representing a relative is another one that will show up on the test. Can you go out and help your mother, daughter, father, son, cousin, whatever? Can you help them buy a house? Sure. But you need to disclose to the seller that the buyer you're representing is a relative. So check with your state and see how deep that relative goes, whether it's first cousins, second cousins, maybe it's just sons and daughters, mothers and fathers. So take a look at that, but you have to disclose whether your client is a relative or not. All right, termination of agency. How do agency relationships ever cease to exist? Especially agency relationships with buyers and sellers. Well, hopefully full performance. Once the house sells or the buyer buys a house, then there is no more agency agreement. Or it might expire. List a house for 4 months. If it doesn't sell, it's expired. There is no more agency relationship. Sometimes it might be the death of a principal or the broker, and this is the one that'll show up on the test. about termination of agency. Notice it says death of a principal or the broker. Who's the principal? It's the client. So that's the client, either the seller or the buyer client. If the seller or the buyer that's under contract dies, then the contract is terminated. What if your broker dies? What if your broker is killed in a car accident? What happens to that agency agreement? It's terminated. It's over. Notice below in parentheses it says not of the salesperson. What if you die? You went out and got the listing. What if you died? Well, the agreement is still in place. Does that terminate the agency agreement? No. No. And you know why? Only because we as salespeople are not part of the agency agreement. Who is the agency agreement? The listing or the buyer-broker agreement. Who are the parties to that agreement? The client and the broker, not us. So it doesn't matter if we die as far as that goes. It could terminate by mutual agreement. Maybe a seller calls up your broker one day and says, you know what, we made a mistake. We just don't really want to sell our house. Would you agree to cancel our listing? If in fact the broker agrees to cancel it, then both parties mutually agree to cancel and it's canceled. Okay? What if the property burns down? What if the house that's listed burns down? Typically that's going to be terminating the agency agreement because now it's gone. Okay? And the last one is breach of contract. That could terminate an agency agreement. Well, how could that contract ever terminate? What could happen there? Well, what if you list a house, the broker accepts the listing, you work hard to find a buyer, and a buyer wants to buy the house. You're in a state that allows dual agency, so you've got a buyer and a seller, and on the day of closing, the seller says, you know what, we changed our mind. We don't want to sell. Happens from time to time. So the seller has breached the contract. Now here's an interesting point. I want you to follow me on this one real quick, only because this could show up on the test this way. A seller has breached the contract, and so it's terminated the agency relationship. But does your broker have recourse? Well, sure. The broker could sue the seller for the commission. The buyer could sue the seller for specific performance, that's from another video, and force the seller to perform on the contract, the purchase agreement, and force the seller to sell the house. But we're talking just on first blush here, a breach of the agency agreement. That would terminate the agency agreement, but then other things are going to follow. Well, that wraps up this episode on agency. I appreciate your sticking around. I have other national exam topic videos out there. Take a look at the list, find one that you think you want to brush up on. I hope you found some interesting nuggets in this video that'll help you on agency get through the test. And as always, you can click on the icon if you like this video. If you subscribe to my videos, and that'd be great if you did, I'd be happy to send you updates. When new videos come out, when I have new updated videos that I put out, I would be happy to let you know when they're out there. And commenting and sharing in the video is always appreciated. Hopefully I'll see you in the next National Exam Prep video.